Hi friends from around the world. Here we have reputation of marks and without due course. May I remember you, if you have seen the video already on the reputed marks, Article 8.5 of the European Union Trademark Regulation, you may know that the scope of protection of reputed marks are higher in that they do not need, so the earlier mark, if the earlier mark is a reputed European Union trademark, it does not need to have identical or similar goods and services. Although the protection, on the other hand, they require detriment of the repute, of the distinctive character of the earlier mark, or to taking unfair advantage of the reputation of the earlier mark. So this is 8.5, right? And we talked about this. If not, it would be good to see the other video before this one here. Because in this case, we talk about the directive of the Trademark Directive. You know that the harmonization of the trademark law in the European Union has been done through the Trademark Directive. And the Trademark Directive in its corpus in general is very much similar to the European Trademark Regulation. So that means that at the end we have in Europe, whether we use national trademark or we use international, so the European Trademark Regulation, we have more or less the same result. Being so that even if it's a trademark regulation, so they have only minimum standards, so the national standards may be even higher than the normal trademark directive, so that is still possible. Now in this case, we do not talk about 8.5 of the European Union Trademark Regulation, we talk about Article 5 of the Trademark Directive. But it talks also about reputed marks. So in the reputed marks, they have, such as 8.5, a larger scope of protection on one hand, and we have the requirement that the trademarks must be similar, the goods must not be similar or identical. There must be a link between in the mind of the consumers between the two marks, and the younger mark must not have a due course, and then the unfair advantage or detriment of the reputed character of the distinctiveness, well, that's all the same. Here I want to talk about due course. What is the case I'm talking about? So I'm talking about Red Bull. It's not a difficult case, so stay with me. You will learn something from it, and it may even help you, because this is against the small guy, so to say. Now we have the Red Bull. Red Bull, you know all Red Bull, the energy drinks from Austria. They sponsor a lot of events, so you should know that. It is for energy drinks, right? And we have an earlier mark, the Bulldog. Now we have a mark, a national mark, a Benelux Mark. You may know that the Benelux, they have one office of intellectual property altogether. Belgium, Netherlands, and Luxembourg. So they have an internal market even before the European Union, and they share some things because they are very close to each other and they are small countries. So they have one office for intellectual property, and if you apply for a trademark at the Benelux Office, you will get for 3 countries. So that Mr. de Vries, a very Dutch name, since before 1983, he has hotel services and provides energy drinks and some drinks for it in class 32 energy drinks for trademark the Bulldog. So he has in total 3 trademarks which applied for in 1990 something. But it is common ground between the parties, Red Bull and Mr. de Vries, that the sign, the Bulldog, was used before 1983. And why 1983? Well, in 1983 it was Bulldog. Sorry, it was the Red Bull. It was Red Bull which filed a trademark in the Benelux for its energy drinks mark, the famous energy drinks. It has become famous afterwards, but no, it started all out in the Benelux at 1983. So what do we have? We have Mr. de Vries. He says, well, since earlier than 1983, common ground, the other knows it. He provided evidence for it because it's up to him to provide evidence for him. He relies on it. That he uses the Bulldog for energy drinks since long time. And 1983, since 1983, we have the trademark Red Bull, which has become very famous and wants now the invalidity of the trademarks of Mr. de Vries. And this invalidity claim was introduced in 2005. Whereas we have the judgment of the Court of Justice. We have this in 2000, was it 14 or so? Can't remember. You have it on the screen. Okay, so what is it? What's it about? It's about the due course, right? It is common ground that it is earlier. So the Mr. de Vries not the Red Bull, but the Bulldog, trademarks were earlier to the filing of the trademark of Red Bull already used, and there was some evidence provided. So it's common ground among the parties. And, well, the trademarks are similar, Red Bull and the Bulldog. The goods and services do not need to be similar, but in that case they are identical. They have energy drinks. So it is even, so to say, a bit more closely related than it would be dissimilar. And still, so the link between the marks within the mind of the consumers is quite clear for the court. Now, where the court is not clear, the Dutch court, which has been seized with the question, is not clear what does the due course means. So what has to be advanced by Mr. de Vries so that he would be allowed to maintain his trademark, and precisely if the earlier use of its mark, so previous to the filing of the Red Bull trademark, if this would be equivalent to due course. Remember that if there's a due course for Mr. de Vries, he would be out of the 8.5 or the Article 5 with the reputed marks. He would be okay, and he can continue to use its mark, right? Okay, let's see what the Court of Justice has been found on that. He was seized by referral court of the Netherlands in order to clarify that question of due course. And it sought a bit about the overriding principle of 8.5, which was an argument which was presented by Red Bull. So if it is a reputation, so with that reputation, it is automatically a coattail, and there's no due course to ride on the coattail of a reputed mark, even so that the mark has been used earlier. On the other hand, the European Court of Justice, they said, well, it is not an overriding principle here to have introduced Article 8.5 or Article 5 of the Trademark Directive. It is rather than to strike a fair balance between, on the one hand, the interest of a party which, with good faith, is using a mark of a certain time and a certain extent, and on the other hand, the justified principle of having a broader scope of protection of a reputed mark. Now, in that context, it mentions, the European Court of Justice mentions what are the elements of due course which can be raised by the younger mark in its defense, so to say. And the first thing is, well, it must be a mark which is not the only due course, but it can be a due course if first the younger mark, the contested mark, is being used earlier than the reputed mark. First condition. Second condition, it has been done in good faith. Now, the good faith is always something interior to a person, so it is very difficult to get to know what is in your head, right? So the Court of Justice, in those occasions, they always went out in order to see, well, what are the circumstances, the objectively appreciated circumstances, in order to conduct a assessment on what is the faith, the good faith or the bad faith of that person. And what do we have here as three elements, how that sign has been used with the public, so whether the reputation, so has the earlier sign already a certain extent a reputation. The degree of proximity between the goods and services. Well, that is also a question. And the economic and commercial significance of the use of that product of the sign, which is similar to that trademark. So it is about a bit has been the younger mark put to a kind of genuine use. Was there a trademark use? Was there, an indication of origin? Try to get a market share from what is the Benelux? If that what is behind, and if the extension into the products which have come after the reputation. So, if, for example, it was in I don't know, in what kind of, in finance industry or in insurance or in services, and once the Red Bull came into, and from that onwards, so the Red Bull mark gains traction on the market, and then the insurance company, it said, well, I will put also on energy drinks in order to, so that would be a kind of thing where bad faith may come into play. So here, in this case, it was not that situation which was present. It was rather that Mr. de Vries, from his hotel business and the energy drinks business, which was earlier, which was much earlier than the Red Bull, and the Bulldog was. It is not a copy of Red Bull, but it is something which has been created earlier and its own originality. So in that case, there was a due course. That was a due course. What is the significance of that trademark? Well, trademark case, it may be that you are representing somebody which is not as important as, for example, Red Bull, or it may be whatever other famous brand you may facing. But if you have a client, if you're representing a client which has an earlier trademark than that one, and it is not as famous as the other one, but it has still its market niche or whatever. In good faith, that is your argument to raise.